Chair, apologies. We don't have our mic. We seem to be muted here, so we are now thinking to use our devices, and apologies for that. But I'm fine now. I will continue. Chair, these are the areas that I will be covering. But Chair, I think in your introduction to the matter, you have covered a bit on the investigation and the allegations that the Commission initiated both in 2015 and in 2016. It covered, as you said, Chair, 28 banks, both globally and from South Africa. The Commission, as you said, Chair, alleged that the banks have manipulated the USD and ZAR currency pair by fixing bid-offer spreads, the spot exchange rate and the exchange rate at the fix. The Commission also alleged that the banks had divided markets by allocating customers in terms of which one trader withholds or pulls his or her existing bid or offer from the market to allow the other trader to execute and complete his or her trade. This conduct, as you said, Chair, was in contravention of the Act. The Commission investigated the matter, and in its investigation found that there was a prima facie case against the 28 banks, and as such, it referred the matter to the tribunal in 2017 for prosecution. Following this, Chair, there were engagements with a number of banks, others through leniency and others through settlement. 3 of the 28 banks, namely Barclays Capital, and the South African Absa Bank, were granted leniency from prosecution following application in line with the Commission leniency application. 2 banks, namely Citibank and Standard Chartered Bank, settled their cases with the Commission with an admission of liability both, and paid a penalty in total of 112 million rand for both of them. Following the referral, Chair, you'd recall we said this when we presented before the committee in 2024. The banks challenged the referral at the tribunal, and in 2019, the tribunal dismissed the bank's challenges to the complaint referral, and the banks appealed this order of the tribunal to the Competition Appeal Court. In 2020, the Competition Appeal Court delivered a judgment dismissing the appeals of the banks and ordered the Commission to file a new complaint referral. In 2020, therefore, in line with the Competition Appeal Court, the Commission then filed a new complaint referral to the tribunal. The banks again challenged the referral at the tribunal, and the tribunal issued an order directing all of the banks to file their answers to the new complaint in March 2023. The banks challenged the tribunal decision to the Competition Appeal Court, And the Competition Appeal Court heard this matter in November of 2023. In 2024, the CAC ruled in favor of 16 of the banks upholding their appeals. The commission then filed an application for leave to appeal to the Constitutional Court against the Competition Appeal Court judgment. Some of the respondent banks that the CAC had found against crossed appeal the decision, and these applications were then heard on the 19 and 21 August 2025. In June, Chair, as you said, 2026, the Constitutional Court delivered its judgment. Chair, in the judgment, I think there were quite a number of important legal and procedural principles that the Constitutional Court pronounced upon, which we detail below. The first one, Chair, is that which was an issue and may still remain an issue more broadly, is that competition authorities have jurisdiction to prosecute international or cross-border cartels. The second one is that a case of a single overarching conspiracy, which is a case that the commission pleaded, may still go ahead in respect of a number of respondents, BNP Paribas, JP Morgan Chase, JPM Bank, HBEU, Standard Americas, and two of the Investec entities, the Investec and the holding company of Investec. The pleaded single overarching conspiracy will also include the 5 banks which have settled with the commission or have been granted a leniency. What this means then is that the commission, the court has cleared the way for the commission to proceed with the referral against 12 of these banks, 7 of whom we will continue to prosecute because the others have settled or been granted leniency. The court released some of the banks mainly on the basis of adequate evidence to link them to the single overarching conspiracy, linked, Chair, to the jurisdiction issue as well. The court also confirmed that the commission, and this is at a procedural level, which is quite key because we are seeing a lot of interlocutory proceedings that happen in our enforcement proceedings, Chair. And so some of these matters that the court has confirmed help us to eliminate some of these problems. The court confirmed that the commission can join new respondents at any stage during prosecution proceeding before at the tribunal. It also affirmed the principles that the complaints are initiated against a prohibited practice, meaning the conduct, and not against a specific firm. On exceptions and objections, the court held that all pleaded facts by the commission must be assumed as proven to be correct. And this is an important factor, Chair, in that when you are having an exception on an objection, especially in a case like this where the parties had not pleaded, the court is saying they can't introduce new facts. In that instance, the court has to decide the objection or the exception brought by the respondent based on the facts as pleaded by the commission, and you accept that those are proved to be true. On Section 3.1 of the Competition Act, and this is the jurisdiction part of the Act, the court did not decide this aspect of the Commission's case. It held that the Commission could not continue to challenge this, as it didn't challenge the earlier decision of the Competition Appeal Court. But it held that, and you'll recall, Chair, in 2024, when we came before you, this was a particularly important matter for us to take the matter to the Constitutional Court, because we wanted guidance on this matter in relation to international cartel or cross-border cartel conduct. However, the court did not decide the matter, and in fact raised this issue of res judicata on its own accord. However, promisingly, it held that the Commission could approach the court in another case raising the same issue. So the matter may still be decided by the court at a later stage. So the effect, really, Chair, is that the Commission partly won, in the sense that we can continue against the respondents that I have mentioned earlier, but the court ruled that in respect of the following respondents, both local and global firms, that the Commission cannot proceed against these respondents in the tribunal on the matter. As I said, Chair, the Commission is now looking at the matter against these respondents, BNP Paribas, JP Morgan Chase, JP Morgan Bank, HSBC. They've changed their name, Chair. I've had it correctly in the other slide. Standard Americas Investec Bank and Investec Limited. Obviously, the Commission will be assisted by Citibank, a Standard Chartered Bank, who have settled the matter, and the leniency applicant. And in terms of the settlements and the leniency granted, they have undertaken to assist the Commission in the prosecution of the remainder of the respondents, Chair. I think, Chair, this brings us to the end of the presentation. Chair, as I said, I have the teams with me, and we are happy to take questions, Chair, and to then be able to respond to any questions that the committee may have. Thank you very much, Chair.
Thank you very much, Commissioner. I think the reports were quite succinct and clear. We will now allow members of the committee to reflect. At least you have sufficient time, members. I don't intend to stop you, but let's not repeat the points that have been made by other members. And probably we can also still come back with a second round, so let's just respect the time. I'm now ready to take hands, colleagues.
Okay, Mr. Thring, Mr. Chance,
Honorable Thring, Honorable Chance, Honorable Gama.
Ms. Mutsikatsi.
Yes, Mutsikatsi will be number 4. Can you please follow like that? I don't want to come in between you. Honorable Thring, Honorable Chance, Honorable Gama, and
Chair,
then Honorable Mutsikatsi.
Mr. Zungula.
Honorable Zungula. Thank you very much. Thank you.
Thank you, Chair. Chair, let me also just appreciate the presentations from the Competition Commission. I think that the work that the Competition Commission does is important to the South African economy, but also important to the ordinary consumer who feels the effect of competition that is untoward and competition that certainly harms the ordinary man in the street. But let me just then go to my questions. I think one of the telling statements in the presentation was that it is easier to enter, particularly for SMMEs. It is easier to enter than to expand. And in my view, Chair, I think that, and I think in terms of the summary in the presentation, I think that this is very clearly where we as the committee, as well as the department, DTIC, needs to focus in order to assist the SMMEs to grow, so that their contribution to our GDP at least gets to the level of that of the OECDs, and simultaneously prevent the exiting. When one looks at the entrance and exits of your SMMEs, I mean, it's appalling. And so if we focus on this particular sector and give additional focus to the sector that's the SMMEs, we could prevent the exiting of thousands of these small, medium, micro enterprises into the coming years. And so I think, in a sense, just a comment, Chair. But maybe looking at some of the questions, what are the proposals that the Commission has to transform sectors that are highly concentrated, such as, for example, the rail sector, which has, in terms of the report, one of the highest concentrations. So what are the proposals to transform a sector such as the rail sector? Secondly, how many firms, businesses, or sectors are being investigated and have been prosecuted for either restrictive practices or abuse of dominant positions? So within the last, let's say from 2017, do you have those particular numbers? And then the Competition Commission has a mandate to conduct legislative reviews. And so from what you have observed, and firms or sectors or businesses that have been prosecuted, what reviews have been conducted, legislative reviews have been conducted, and if they have been, for what sectors and or businesses? Then, Chair, just on the rand manipulation, some approximately 220 million rand was paid by 3 banks. That was just my quick calculation. There were 3 banks that paid approximate fines of approximately 220 million rand. And so my question with regards to these particular banks, and I know that there may be others now that the Constitutional Court has given permission for the Competition Commission to go ahead with their investigations into some of these other banks, and so there may be more fines. But the 220 million that was paid by the banks, fines that was paid, has the Competition Commission looked at this rand manipulation? What is the cost to the economy? It may be difficult because that cost to the economy also then gets transferred as cost to your consumer. So has there been some kind of calculation in terms of what the cost to the economy, the consumer was? And then the fines that have been levied, do you view these fines as being commensurate with the crime or the damage caused? And then just maybe the last question, why was there inadequate evidence in terms of the Constitutional Court? Why was there inadequate evidence to link the banks to the overarching evidence, which appeared to have let some of the banks off the hook? So apparently the Constitutional Court says that, in terms of the report, that there was inadequate evidence to link the banks to the overarching evidence. So why was that case? Why was there inadequate evidence? Thank you, Chair.
Good morning, everybody. Welcome to the Competition Commission, and the presentation was very informative. I just have a couple of questions. Number one, I'd be very keen to look at the raw data on which the report was based, because some things which strike me as a bit odd and counterintuitive is the high concentration that you reported in the manufacturing sector. I think in the region of 60 to 70%, and the comparatively low concentration in the financial sector of somewhere around 20% or thereabouts. Now, nobody ever comes to us and says the manufacturing sector is too concentrated, but lots of people always come to us and say the financial services sector is too concentrated. So I'd like to see the raw data. Could the Commission please supply the committee with the data in whatever form it's available, so that we can interrogate what companies are actually the dominant ones? 40%, 3 companies comprising 40% of the market. That would be obviously a sign of dominance, but I'd like to just see the raw data. My other point is not really a question, but it's just to point out that the point was made by the Commissioner and by Honourable Thring that the scaling challenge is the most important, and it's long been a factor in the South African economy's distortion, is that we have a very small middle segment in our economy. And as was pointed out, we have a lot of very small businesses and a few very big businesses, but the problem is we don't have the middle. And we often refer to the middle stunt in Germany, which is a very good example of how mainly small family-owned businesses grow into becoming global brands in their niche sectors. And I just think that it's something that we as a country and as a committee need to be looking at. What attempts are being made to grow supply chains, to link potentially large with medium to small businesses who have the potential to grow and then can become equally dominant in global supply chains as their, for example, German counterparts. It's something that I think has to have an intentional strategy around, not necessarily around picking winners necessarily, but facilitating through finance or market access channels the ability of big businesses to work more closely with smaller businesses to build those global supply chains. And then just on the market concentration report, I've been following this quite closely over the years, and it does seem that there's a battle going on which doesn't seem to have an end. I'd just like to know from the Commissioner what, if any, equivalent international investigations have taken place. Because I would find it very odd that South Africa was the only country in the world where such cartel and collusive behavior was taking place, if it indeed did take place. And if that is not the case, then which other countries have had investigations, and where banks or other financial institutions have been found to have been collusive and have been fined as a result? Thank you, Chair.
Thank you. The next one is Honorable Gama.
Thank you, Chair. Good morning to everyone, and thank you very much, Commissioner, for the report. Commissioner, your report shows that 97% of registered businesses share only 22% of turnover, while 3% of businesses command 78%. And you also tell us that it is easier to enter this economy than to grow in it. For Parliament, I think it's important that that the question is no longer simply whether concentration is declining. The question is whether economic power is actually changing hands. Can you tell this committee what percentage of South African turnover is controlled by historically disadvantaged South Africans? How many Black-owned micro and small enterprises have graduated into medium and large enterprises? And how many jobs the transformation has created, and what measurable targets can you propose for changing those numbers over the next 5 years? Because I think if economic power remains concentrated despite some reduction in market concentration, we should then have some targets that are set in order to ensure that productive assets and turnover begin to shift to the majority of South Africans. Turning to the banking cartels, thank you very much also for giving us an update on that. And I think what is painful is the amount of time that this procedural litigation has consumed, which is over a decade. I would want to know whether you've got a time-bound litigation plan to get the matter before the tribunal on the merits. By what date do you expect the tribunal finally to hear evidence on whether the rand was manipulated, rather than further interlocutory arguments about pleadings and jurisdiction? The Barclays Bank leniency detection instrument. What exactly did South Africa obtain in exchange for Barclays Absa immunity? Are the documents, trader testimony, chatroom records, etc., or identities of participants and evidence capable of establishing the single overarching conspiracy? Because if a leniency applicant does not provide
capable of coordinating
sufficient
real world power is far too
sorry, someone is passing
Yeah,
by.
can you please respect the meeting, colleagues, and close our mic? I know others are in multiple meetings, please.
Yeah. Sorry, Chair. I'm saying if a leniency applicant does not provide sufficient evidence to secure prosecution of the cartel it disclosed, then under what circumstances can its leniency status be reconsidered? So I'd like to understand that. Then the issue of the Constitutional Court in terms of the interpretation of Section 3.1 on its merits, you do say that it expressly left Section 3.1 open for another case. Do you have a litigation strategy to obtain an authoritative Constitutional Court determination that the foreign firms whose conduct materially affected South Africa are subject to our Competition Act, regardless of whether the cartel meetings actually took place? I don't want us to wait for another 10-year case. So I think as Parliament also, we may want to consider whether or not the Section 3.1 needs some kind of amendment, which could make it explicit that subject to appropriate constitutional safeguards, what a prohibited practice is, so that we're able to deal with this issue rather decisively. I don't know, Commissioner, whether you've quantified the damage caused by the alleged rand manipulation. What did this conduct actually cost South Africa and South Africans? So I think it's very important that maybe you just share with us, because if the economic damage was measured in billions, why should settlements be measured in tens of millions? I think Mr. Thring said when he calculated, it got to about 220. I think I saw 112 million thereabouts. So I think it's important for us to see whether if the damage is huge, why don't we make sure that we also get huge compensation of that? So after 10 years of litigation involving this cartel affecting the price of the rand, Commissioner, what do you think must change in our law or in our investigative capability or in our leniency regime and our litigation strategy so that the next multinational cartel cannot spend another decade avoiding a hearing on the merits? Thank you very much.